Thank you for joining us today. We're going to get started, and my name is Mary Jetton. I'm the CEO of TrackLight, and we've been doing these webinars since last year. We can now say that, so Happy New Year and welcome to 2014, everyone. I am extremely excited to have Sharon and Toerek today come and talk to us about why marketers should care about IP. We run into, just in the business that we're in, where we're doing a lot of inbound marketing and education, hear a lot that people feel that they don't have IP because they're not in a techie space or they don't have patents. So the exciting thing about today is that we're going to hear why these marketers should care, and not just from someone at TrackLight, but from Sharon, who is a very well-known, nationally recognized author and speaker. She's at Licata and Toerek in Cleveland, Ohio, and she focuses her practice on IP law, or intellectual property law, but she, although located in Ohio, she has a national practice, and her clients are concentrated in advertising, marketing, and the creative services industry. And just before Sharon gets started, I just wanted to say that it's very interesting because Sharon was presenting at another conference, BOLO, and when she was up on the stage, one of our advisory board members was sitting in the audience and was so excited by what Sharon was saying and how it fit with our mission at TrackLight to educate around IP, that he right there and then sent me all of her information and told me, go ahead and stalk her on. So I'm so glad that I did, and super excited to, and I'm going to thank Sharon in advance for taking an hour out of her day. I'm super excited to hear her speak. So now we're going to hear from
Mary. Thank you. It's absolutely my pleasure. And what I'm really hoping today is that even though we're all communicating virtually this morning and this afternoon, it's afternoon here in Northeast Ohio, that this is really a conversation more than something that feels like a lecture or a law school class. What I'm really passionate about and what I share a passion with TrackLight about is helping companies of all sizes. I tend to focus on the creative services field, as Mary indicated, but intellectual property really is all around us in companies of all shapes, sizes, and industries, and sometimes in places where you don't expect. We are going to focus today on why marketers should care about intellectual property and what the most common situations are that arise in the marketing and advertising realm that relate to intellectual property, and talk from a preventative perspective about what you can do to spot and then protect your intellectual property. And then in some cases, if those things haven't been done in advance, how to sort of react to situations that might emerge. And while we don't have any slides that are directly on point on this, on definitional issues, we'll start by my sort of discussing really briefly what the types of intellectual property are that we're going to be focusing on today. We will not really be talking about patent for a couple of reasons. First of all, it's while it's critical, it's highly technical, and really the time frame we have today doesn't allow for it. But I'll certainly answer any questions related to the patent concerns that you might have if time allows, or you can contact me offline about that. So I always like to tell clients and groups to whom I'm speaking that really, as lawyers, our job is kind of to sweep the mess up that occurs, that gets created by business who adapts to technology. And really, this is because the law is never really completely caught up with all of you, and all of you are trying to completely be caught up with technology. So really what we like to say is that technology leads in creating some of these potential issues. Your businesses all adapt to the challenges that technology creates and allowing you to create IP. And then the law really reacts to situations that arise and tries to prevent them from occurring in the future. So there's not always a clean legal answer to every situation that might arise. So if you're a marketing professional, some of these are going to sound very familiar to you, but you spend your work lives working on product launches, dealing with implementing new technology platforms and tools to help get your message out or sell your product or your service or your client's products or service if you're an agency. With content generation or content curation, if you are gathering content from all sorts of places and trying to leverage it and put it together for your needs or your client's needs. New strategy to create and implement, all of which is likely proprietary to you or to your clients and would do you harm if it was out in the market and in the hands of your competitors. And then new creative treatments of all of the above. And every single one of these tasks, it creates intellectual property. And when we're talking about intellectual property, what do we really mean? Today we're going to focus on three different silos, really. Trademarks, which are words, logos, graphics, sounds, anything that can indicate the origin of a product or a service. So anything that indicates who is creating and selling any particular product or service can be a trademark and identify a brand. The copyright is another area of intellectual property we'll spend a lot of time on today, and that is really a term that refers to a group or a set of rights that you have in any original creative product. And it could be technology, it could be advertising copy, it could be a mobile application, it could be software, but folks in marketing create tons of new work every day that is subject to potential copyright protection. And we'll also talk very briefly here and there about proprietary information and trade secrets. And this is information that is confidential to your company or your client's company and could put you at a competitive disadvantage if it got out in the marketplace and was implemented by someone who competes with you. As I said, we won't really talk much about patents, but just very briefly, a patent is basically a legal monopoly on some sort of novel invention, solution, application that there's no prior art in the market that competes with and enables you to exclude other folks from making or selling similar products, methods, applications. So with that in mind, let's talk about the most common scenarios that I see and we see in our practice here dealing with marketers as they relate to intellectual property. The first is protecting intellectual property in either a new business pitch if you're an agency or in what I'll call the ideation phase when internal marketers or when marketers and their agencies or vendors are creating new concepts and new ideas about how to sell the products or services of the marketer. Secondly, marketing and advertising are industries that make tremendous use of virtual and freelance working relationships. And while this is becoming more common in just about every industry these days, given the economy and the way the world of work is changing, it has always been true and continues to be even more true with the formation of virtual agencies with strategic alliances between firms who work on common projects. And who co-create a lot of intellectual property together without always necessarily reflecting in an enforceable way who's going to own the intellectual property in that end product. The rights to completed work that is done at the end of the day, particularly by outside vendors like a marketing agency or any third party, photographers, videographers, software developers, mobile app developers, what do you need to do to make sure that the rights to that completed work end up in the correct place legally? Because as we indicated in the promotional materials for this webinar, the rights to the completed work do not always follow the money. In fact, they really never follow the money unless there's a writing that goes along with that transfer of funds that indicates who owns what. Selecting a client brand or rebrand. When you're in the process of developing a potential brand trademark, there are very specific steps that need to be taken and taken as early as possible to clear and then protect that brand and then maintain protection of that brand. So it's a commonly seen scenario and hot button in the marketing world. And then finally, we'll talk briefly about how IP arises when you are producing content marketing or using social media to get the messages out about your services or your products or your clients' products or services. So that's sort of the lay of the land today, and I am happy to answer questions as we go along, and I'm going to rely on Mary to be our moderator here and sort of interrupt me on your behalf if she sees any questions there that we'd benefit from taking a pause and having a discussion about. So an area that we get a lot of inquiries about is from our clients who are in the agency world, or sometimes they're in-house marketers, and they want to know what happens to the rights in new ideas or new potential concepts that get presented to us. Particularly, when do we own them as a client, and what happens if we don't hire the agency that presents the ideas to us? Who owns that stuff, and what do you do if the relationship doesn't come to fruition, but the ideas get implemented by the client along with somebody else? What are the implications to that? So what I like to tell people first is get the ugliness out of the way, and that's that nobody owns ideas. The intellectual property laws, at least in the United States, don't really protect the expression of ideas unless they're in some sort of tangible form, which we'll talk about in a minute. But short of any writing between the parties prior to the ideas being expressed, there really is no obligation on the part of whoever's receiving those ideas to keep them confidential or refrain from implementing them. So what I like to remind folks in this situation is that be very careful before you enter into a discussion about concepts or ideas. And for this reason, many companies have definite policies about refusing to accept unsolicited ideas or concepts, particularly creative companies like the card companies, Hallmark, American Greetings. They will, in most cases, you'll either get an automatic bounce back if you send stuff automatically, or they will physically send it back to you because they do not want to have to monitor handling rights in unsolicited content or ideas. So there's a couple things you can do in this situation to sort of clarify this matter, and none of them might be palatable to you, but they create options at least so that you can walk into these situations with open eyes. First of all, if all parties are willing, get a mutual confidentiality agreement or non-disclosure agreement in advance before the expression of the ideas, the concepts takes place, or before the business pitch if this is a new business situation. And focus on mutuality if you want a prospective client to agree to the terms of the NDA. I'm not going to tell you that prospective clients in the marketing industry like to be approached with these non-disclosure agreements, and in many cases they will not sign them. But at least you know that up front and there aren't any surprises about the risk you're assuming by disclosing information to them in a new business pitch. The second option is, as I said earlier, you can decide that you're going to assume the risk of pitching this client with your great ideas, even though you might not get hired to do the work, and you may regard that as a sensible business investment to make, and that's a valid decision as well, but it's one you should be making, and you should be making it, like I say, with open eyes prior to the new business pitch. There are some alternative things you can do as well to use copyright law to actually protect yourself in these situations. Copyright law will only protect the actual physical expression of your ideation. So if you are in a position to, during presentations, put as much of your thinking in a physical form as possible, storyboards, written memorandums, detailed proposals, videos, anything that is an actual physical expression that can be read or viewed, touched, if you will, can be subject to copyright protection. And if that's the case, then you can certainly use the copyright law to protect yourself, along with copyright notices on the documents and copyright ownership language. You can also, if you're going to be expressing potential ideas or concepts in written proposals, put ownership clauses in the proposals so that it's very clear that unless you're compensated the ideas are your property and are not able to be implemented. That can be questionably enforceable if there hasn't been any consideration exchanged by the parties, but it's a great expression of your intent. So just understanding what happens to ideas that are disclosed without any protections in advance, along with how you might be able to use copyright law, can put you in a much better position when you're in an ideation or a pitch situation. Another trend we're seeing increasingly in the industry is very sophisticated marketers and the agencies or companies who want to work with them are agreeing on these issues in advance of the pitch. What this usually involves is some sort of exchange of nominal consideration. By no means would I suggest that it is enough to make the marketer who is pitching whole for the amount of time and money they're spending to get ready for the pitch, but at least it settles the issue of who's going to own the rights to what that comes up in the new business pitch. And again, it is an assumption of the risk and an agreement on the point of who owns those rights. So I'm going to pause there for a second. And Mary, I'm not sure if you're getting any questions on this issue or if you've got any questions, but before we go to the next hot button, I thought I would take a pause to see.
I didn't get any questions yet.
Okay.
And please, people can feel free to jump in. But do you want to just clarify for people, because this is a question we get a lot, like, write notice on something, does that mean that I still have to register it with the U.S. Copyright Office, or is it good enough?
Okay. Well, I think that's a great question. And copyright in any original creative work arises from the time that work is created. So you don't technically have to register your copyrights with the U.S. Copyright Office to own copyright in your work. However, you get significant procedural advantages in some cases by filing registrations of your work. And first of all, it gets you the right to collect statutory damages in the event of an infringement, so that if your work is misappropriated, many times the cost of pursuing an infringement action is just not practical for the person whose intellectual property, whose copyrights have been taken. So having the right to collect statutory damages means that you're not limited to just collecting your actual financial damages. So there is that. And secondly, if you are to the point of needing to sue for copyright infringement, or you make the decision to do that, federal law in the U.S. requires that you have copyright registrations in your work before you can file that lawsuit. So you'll be ahead of the game if you've already got your registration. There is a process for being able to expedite your registration if you need to file an infringement case, but it's pricey, and you don't want to find yourself having to take advantage of it unless it's really an emergency. So, and then in addition to registration, just the process of putting copyright notices, and they can be very simple and straightforward. Just the term copyright, or the C in the circle, the year of creation, and the name of the author of the work. So either the company, if it was created by an employee of the company, or the name of the owner if it was created and then assigned to the company. So those are some things that you need to know about whether a copyright is enforceable, protectable, and what the additional steps are to take if you find yourself in an infringement situation.
Okay, thank you, Sharon. And I just want to let people know that if you want to ask questions, beside the little icon of the phone where we ask you to mute, and thank you everyone for muting, to the right is a little chat bubble. So you just press on the bubble and you can just type your questions in there, and I'll be moderating while Sharon continues.
Great. Thank you, Mary. All right, well, moving on. In addition to protecting ideation and concepts in a new business pitch, a hot button issue we see very frequently here amongst our marketing industry clients is the intellectual property implications of using virtual or freelance work arrangements. Most of us need to, at some point or another, engage the services of an independent contractor, a contract worker, whatever your terminology there is, a freelancer, someone who is not in your full-time employment or your regular employment, your W-9 wage employment, to help you do creative work or fulfill creative work that you need to prepare for your client. And I use that term very loosely. We could be talking about getting a freelance mobile app developer in on your team to temporarily help you with a project, using a photographer or a videographer to help you execute a project, any circumstance in which you're using an outside resource. There are several hot-button issues that occur in these relationships related to intellectual property protections, and those include promising or warranting that the work that's produced by the freelancer is actually original, or that they have the right to provide it to you. And that seems like a very obvious point, but I can tell you I've been in the situation of having to represent agencies who have hired freelancers who didn't produce work that was original. They produced plagiarized work, and it was a really big mess to have to unwind afterwards. So it does occur. It's been pretty rare in my practice, but I have seen instances of it, and it's very expensive to unwind afterwards. Client confidentiality and other restrictive covenants, and I'll cover those at the same time. If you are an agency owner and you would be at a competitive disadvantage if your client directly hired one of your independent contractors and worked with them outside of their relationship with you, then you need to make sure that you've got restrictive covenants in your legal arrangement with the freelancer that would prevent that. You want to also make sure that the freelancers you're working with agree that your business and that your client's business, or if you're an in-house marketer, your company's business is absolutely confidential, and that they're going to maintain the same degree of confidentiality that employees are required to about the affairs of the company. Work rights ownership. It's a common misnomer, and we'll talk about this in a little bit more detail as time permits, that if you've retained an independent contractor or an outside firm to help you create deliverables or assets, that you own the rights to them once you've paid. And that's not the case unless you've got a writing in between the parties that says that it is the case. Law in the United States requires that all transfers of copyright in any original work have to be done in writing, and that's whether money changes hands or not, which is why we stress the point in the blog article that promoted this webinar that the rights don't always follow the money. So you need to make sure that in addition to triggering rights upon payment, that there's actual language in the agreements that you've got with your freelancers that transfers the rights to you. And then in some cases requiring your outside agency, if you are an in-house marketer, or requiring the freelancers that you work with, if you're an agency, to have insurance coverage in situations like accidental infringement, which does occur once in a while. Sometimes there's an inadvertent misappropriation, or sometimes there are claims made that are not valid but still have to be defended, and that's where having insurance coverage in place can help you in an intellectual property misappropriation situation. So this is sort of the high points of a framework of an agreement you'd want to have in place with your freelancer. I add an extra slide in here because if you get nothing from this presentation after you hang up the phone other than this, it's that all agreements related to the transfer of rights in creative work in the marketing space, in any space, have to be in writing. If you don't have it in writing, then you don't own the rights technically. And if you don't own the rights, then you can't assign the rights to anybody else. So it does create a domino effect of all these rights being floating out there in space in different places, and they all need to be sort of gathered together in one place, and the only way you can do that is in written agreements. Okay, so no handshake arrangements. I know they're extremely popular. I have clients who probably still use them here and there, but it's sort of a recipe for a domino effect of problems, because your client will certainly not be happy to know that you've got rights floating out there that you haven't acquired on their behalf. So do yourself and your client a favor and make sure you've got solid written agreements in place related to the intellectual property transfer. All right, so we talked about some of the critical contract provisions, but just to review them again, you want a transfer of the intellectual property to be in writing and very clearly expressed. You want the contractor to warrant that the work that they've provided to you is original or that they have the right to give it to you. You want to provide for confidentiality about the agency's business, about the client's business. You want to provide for non-competition and non-solicitation so that trade secrets are all tied up and cannot be disclosed by anybody who works with you. And then we talked briefly about insurance coverage. So what if you haven't done any of these things and you find yourself in need of having to sweep or clean something up so that everything is neatly tied up? The best course is to get a written assignment or transfer of intellectual property rights after the work's been completed. It'd be best to do it in advance, but if you haven't done it in advance, get the contractor before they move on to some other project or a client to sign an assignment agreement so that you own the rights to the work they've done for you. Enforce your contract if it's breached. And I like to tell clients that you don't do yourself a favor in most cases by not treating similar situations similarly. Selectively deciding not to enforce these agreements, as unpleasant as they can be, nobody likes conflict, but enforcing them selectively puts you in a weaker position if you let one situation skate and then want to pursue another. So be consistent in your enforcement of your contractual agreements with your freelancers. All right, let's talk for a minute now about, we've talked about sort of the link in the chain between freelancers and agencies. Let's talk about the link in the chain between agencies or vendors of any kind that create creative work, whether you're a software developer, a video development firm, maybe you're a content creator, an editorial writer, whatever you do. How do you get that work from the agency to the client? And usually when I broach this in a presentation, I get some quizzical looks like the agency will say, why are you making a big deal out of this? We're fine with our clients owning the work. We're in the business of doing this for financial compensation, and we don't need to own it afterwards. And then on the client side, you've got, why are you making this an issue? Of course we own it. We're paying for it, and naturally it's fair. The reason I stress it is because this is a situation where the copyright law doesn't necessarily seem commercially logical or commercially fair. And once people understand that, it's an easy step to taking the necessary precautions via the paperwork that's required to make sure you do own the rights to the work you're paying for or asking third parties to do for you. But it's a conversation that needs to occur because it creates a lot of unpleasant surprise if the contracts that are in place or the relationships that are in place don't address it up front. So remember that IP ownership doesn't follow the transfer of money. And also remember that if you are an agency representative or owner, correct language in your agreement about when intellectual property transfers, specifically making it not transfer unless the money has changed hands, can be a very significant leverage to you in a contract breach situation. So it's another lever to use if you haven't been paid for the work you've been done. So, and again, I stress that you'd be very surprised how infrequently these terms and conditions are put in writing in advance by the parties. Marketing is an industry that moves very quickly, very virally, and parties get excited and are under the gun and don't take care of this stuff frequently in advance, and so it needs to be handled sometimes on the fly. So it's good to have standard procedures in place to deal with this. So how do you prevent these problems? Create an internal process, as I've just mentioned. Have a standard set of documents and forms that shore up these rights to the intellectual property. If you use a lot of independent contractors, have a standard independent contractor agreement ready and able to go, and have somebody in charge of making sure all these rights are secured in any work that's created. If you use a lot of third-party agencies and you are an in-house marketer, have a standard process, and many of you might have procurement departments that help you with this, or finance departments, or operating officers. Whomever it is, have some central contact point who is responsible for making sure that there's something in writing between the parties that addresses the issue of who owns the rights to what. And if you're not transferring all the rights, if you're entering in anything other than an actual assignment of all the rights, then it's a license. And if it's a license, then you need a license agreement. And that agreement needs to say what rights you're giving somebody to use and when they expire and under what circumstances they can't use the work that you're providing for them. Okay? So if you've not done any of this, if you haven't heeded my advice and you find yourself in a situation where this has got to be addressed after the fact, again, you can get an assignment of the work from your agency after the fact and after payment's been rendered if you're an in-house marketer, and have a standard assignment document ready to go for these situations. As I mentioned before, if there's payment disputes between agency or marketing firm and client, the IP ownership issue can be a lever to help resolve this matter. And if things change and the client ends up wanting to expand its use of the creative work that's prepared, you can always negotiate broader license terms or narrower license terms, as the case may be, for an adjustment in compensation. All right, taking a break from copy right now, let's talk for a moment about the fourth hot button that we see most frequently in the marketing world, and that is the trademark issues that arise with brand selection or brand implementation when you are creating a new product, creating a new name for a product, starting a new business. The most frequent issue we see in these situations is clients or clients plus marketing firm getting too far down the path of selecting a brand that everybody seems to like and feel is appropriate for the business or the product, but they haven't taken necessary steps to clear. Alternatively, what I get are inquiries from folks who want to register their trademark, but the clearance work they've done has only consisted of seeing whether or not the name is available as a domain name. And sort of this false sense of safety that they have, that if they've been able to buy the domain name, that they're in the clear from a trademark perspective, which is not necessarily the case, which is rarely the case, actually. Domain name availability and clean Google search results are not the same as trademark clearance of a potential new brand. So you need appropriate due diligence. You need to work with an appropriate trademark search or trademark attorney who understands how to do the necessary due diligence to protect the brand. And you need to start the process as early as possible. Probably the most common issue we see is that folks get too far down the road and spend a lot of time and money and energy on a brand that ends up not being available for some reason because it won't clear. And those conversations always make me a little sad because I know that a lot of energy has been spent around trying to adopt that brand, and we're not able to secure a trademark for them. Or even worse, there's a potential competitor out there using a similar mark. So start this process early to give yourself time to adapt if you're not able to use your first choice, if you will. And once you've decided on a potential brand mark, you want to start your trademark application and registration process as promptly as possible. In the United States, we engage in intent to use trademark practice, which means that you can file for a federal trademark before the mark in use to sell something. So take advantage of that along with your legal team to get your trademark brands registered as soon as possible. The most common mistakes we see in marks that are adopted or that clients attempt to adopt, and the number 1 and 2 reasons why trademarks get refused at the Patent and Trademark Office in the U.S. is that they're either too descriptive or generic in association with the products they identify, or that they are likely to cause confusion in your industry because there's other existing marks out there that identify similar products or services. I get asked a lot, what's an example of something that might be too descriptive or too generic? And the best way I can explain it and this is counterintuitive to folks who are marketing professionals, but the more fanciful, the more made up a mark is, the less likely it is to appear in any language, English or otherwise, the stronger a trademark it actually is. And that seems common because marketers like their marks to describe some attribute of the product or service they're selling. If you can think of words like Xerox, which are entirely made up, and things in that vein, those are the strongest and most protectable word trademarks. And you can't always get something that's that fanciful, but if you're thinking along those lines, that's sort of the way to think about how to choose a mark that's stronger. Okay. All right. If you've adopted a trademark and then you end up having a problem with it post-adoption, there are a couple things that are sometimes successful to do to preserve the trademark. You can acquire the mark of the other owner who objects to your registration. Sometimes they end up being for sale. Sometimes the competing mark is not being actively used in the marketplace, but there's still an existing active registration out there. So acquisition is sometimes a possibility. Modifying your mark with either spelling, graphics, or language can sometimes work. If at the core, though, your mark really conflicts with someone else's in a similar industry or for similar products or services, it's probably not going to be a successful strategy. Third of all, distinguishing your mark in some way, shape, or form, either by very clearly identifying what it is you sell in connection with that mark and how and why it's different from what someone else sells using a similar mark. Can also sometimes help when you are trying to get your trademark registration pushed through at the Patent and Trademark Office. And I don't want to get too far in the weeds there, but those are some things you can do to sort of save yourself or save the mark if you've gotten too far down the road to try adopting another one immediately. So let's talk a little bit very briefly about how to use intellectual property correctly in content marketing and social media. I mentioned earlier that marketing is a very quick-moving industry, and this isn't any more evident than in the areas of content marketing. And I'm getting a message that I've lost my connection. Can everybody see the deck?
Yep, we can still see that.
Oh, great. Okay, it looks like I've reconnected.
Good. Okay.
Okay.
Good.
Sorry. Social media and content marketing are viral and quick moving, and that means that mistakes are much harder to fix in a meaningful way or in enough time to actually make an impact. So you want to get it right the first time. And the most common intellectual property hot buttons we see in content marketing and social are those related to posting of freelance created content that the rights are not cleanly owned to, repurposing content and sharing content of others without the necessary permissions or attributions. Remember that just because it's out there on the internet doesn't mean it's free use to grab it and use it for your own promotional purposes or your client's promotional purposes. Being very careful about posting of proprietary, competitive, or sensitive information, either in your original or curated content or on social channels is something to pay very close attention to. And remember, you still need to follow those trademark usage guidelines and conventions when you're using marks on social. And particularly if you're doing any competitive advertising or competitive claims in your content marketing or on social media, you want to make sure that you are not breaching any rules or laws regarding trademark usage. So some guidelines to stay out of trouble in social and in content marketing related to IP. Get permission if you're reposting the content of any person who's not your employee. If you are on your company's blog going to repurpose content that's created by another party, you want to get permission. And then following that, you want to make proper attribution when you're posting any original intellectual property of someone else, whether it's content, which would be copyright protected, whether video or editorial, or trademarks. You want to make sure you make proper attribution of who owns the rights. a good example, probably a proper attribution of trademarks, would be if you're using case studies in your content marketing, and that requires the use of proper trademarks of other parties. Follow the proper brand standards and trademark guidelines. Companies spend lots of time and lots of money putting together brand standards manuals, rules about the use of trademarks. Make sure you're not getting sloppy about that just because you are using social media venues, which are very quick and feel very informal, but still need to have the same rules applied related to intellectual property protection. And don't use competitor brands in your marketing unless you are willing to follow the same laws of comparative advertising you'd be following in print on social. This applies to trash talk about your competitors' products, claims regarding the culture of another company, regarding effectiveness of products. Remember, comparative advertising is comparative advertising. And so you need to follow the same standards and rules. And if you are someone who likes to use network marketing or blogging networks to get the word out about your clients' products or services or your products or services, you want to make sure that you're following the law regarding testimonials and the FTC's requirements. And that's not as much as an IP question as it is a regulatory question, but it's definitely relevant in the social media area. All right. If you haven't done anything to prepare for this and you need to react to a problem, the best advice I can give you is be very prompt about correcting and taking down violations as soon as you know about them. Get rid of the objectionable content. Get help from your PR partners about apologizing if it arises to the level that would require an apology. Get rid of competitive ads if they are not 100% compliant with the law on competitive and fairness in advertising. You can always get an after-the-fact license or written permission to use content and intellectual property. You have less leverage, obviously, to do that on favorable terms than if you request it beforehand, but it is possible. And don't use social channels to talk about information that could be proprietary. And the best example of this is that if you consider your client list or your customer list proprietary, think twice about your use of testimonials and whether or not that makes sense, because once your customer names are out there, they're free for people to grab. So I want to talk real quickly in conclusion about some recent developments we're seeing in the law related to IP in the marketing space. The one I'm personally most concerned about is the release of new top-level domain names. ICANN, which is the entity in the United States that is in charge of issuing new top-level domains, and that's everything to the right of the dot, is releasing potentially hundreds of new more top-level domains. And as you can imagine, this creates a lot more real estate to protect on the Internet for trademark holders. So if, for example, you are a company or your client is a company in the food or the restaurant industry, and someone owning their domain .brand, .food or .restaurant would be a competitive problem for them, you're going to have to be a lot more proactive about protecting trademarks and monitoring usage of them on the Internet. So I'm concerned about this one in particular because ICANN has actually just released its first dozen or so new top-level domains. And there's a clearinghouse available, but you've got to have a federal trademark registration to take advantage of it. So I don't want to get too far in the weeds there. But yes, I'm sorry, Mary?
Oh, this is Emily. I apologize. There were some technical difficulties, and it looks like your screen dropped. So we're back to sharing on my screen. Which slide would you like me to be up on?
So we are on the Pinterest and copyright infringement slide.
All right. What happened? Let's take a look here.
It's the end.
A little further?
I can't see your screen, so I'm not sure. But I'm just going to keep talking while you find the slide. We were just talking briefly about ICANN's release of new top-level domain names. Another recent development, and frankly this one is not as emergent as it was probably 6 or 9 months ago, but is the copyright ownership issues created by repurposing and repinning of content on Pinterest. Just know that every repin of content that you see is a potential copyright infringement. And while really the jury is out on whether we care in most cases, because most of us who put content out on Pinterest want it to be repinned and shared with other folks, and that's our purpose for being on the platform. But if you are repinning in a commercial context, just make sure you've got the rights to repin that content, because you don't want to create a potential copyright issue. Additionally, we occasionally see, and this will flare up and then die down, and flare up and die down, but disputes over who owns what I'll call social contact data, and these are Twitter follower bases, fan bases, Facebook fan bases, LinkedIn contacts. The law is fluid on ownership of these sort of contact databases, which can be a source of very rich data for companies. Knowing who is loyal enough to be a fan of your brand or a potential customer who wants to engage with you on social is important, and so ownership of this data is critical too. Basically, Twitter handles that include the brand names of the courts and the law are coming down on the side of the company owner. LinkedIn links, it depends upon the company policy related to who owns the employee's LinkedIn set of links. Facebook fans typically belong to the company and absolutely belong to the company if they're on a company page. So that's something to keep in mind. And I think with that, I'm going to conclude my comments and see if we've got any questions in our remaining 5 to 10 minutes, and just open it up for conversation.
Okay. Hi, Sharon. It's Mary.
Hi.
I don't know what happened there. We actually had someone join us in person here at our office, so we've got your webinar going all over. Kind of exciting.
Oh,
so we had a few questions. So one person said, I've heard registering a copyright is easy. Do I need an attorney to help me with a copyright registration or a trademark registration?
So it's an excellent question. I would say that if you are inclined to engage in sort of self-help in this area, that understanding the copyright registration process is much more straightforward. For the past, I want to say 2 years now, you've been able to apply for copyrights online, and that application process is actually pretty simple and straightforward, and it's the kind of thing that I think most folks can adjust to learning to do on their own, or you might want a lawyer to show you how to do the first one or two, and then I think you'd probably be good to go. Trademark is not an area where I advise self-help, and I realize that I've got a bit of a conflict of interest because I practice law, but I will tell you that the online application process for trademarks looks deceptively simple and is quite easy to get wrong. So you can waste a lot of time and a lot of energy improperly preparing the application. So I'd use a lawyer for the trademark work and learn how to do the copyright registration work on your own if you had to make that choice.
And just to help you out, Sharon, it's Mary, and TrackLight does not do legal services. And to let you know that we did some of our own trademarks and learned the hard way early on because we did have a law student help us, not under the auspices, just as a volunteer, and we made a mistake. And there are do-overs when you make a mistake, and you have to then you end up refiling. And actually, the USPTO, the United States Patent and Trademark Office, if you look at their website, it tells you that you should seek legal advice for an attorney, and certainly that's what that's certainly what we tell people who use our tools to know they might have a trademark. So I have another question here, which is, would the freelance contract written or provided, would that come from the company or the contractor?
I think that if you are someone who acquires the services of a lot of independent contractors, or you get a lot of work done then I really think you should have in your arsenal or your toolkit a standard freelance or independent contract agreement. First of all, this is a true rule in any aspect of contract drafting in the law. The person who's drafting the contract is always got the benefits of being in a driver's seat in terms of how the contract reads. So that's just a basic. But secondly, if you are managing a lot of freelance situations or relationships, it's a huge time saver to have these documents at the ready, so that you don't have to wait on the freelancer to get it to you. And then I'll say, secondly, you're the one who's got more to lose as someone who's acquiring this work from a freelancer than the freelancer does, because if there's nothing in writing, then the freelancer still owns their work. So, and if you're a freelancer on the line, that's something for you to keep in mind if you don't get paid by a client. But I think it's the company or the firm that's acquiring the work from the freelancer who should take that ownership responsibility.
And we kind of have a follow-up question on that. How do the rights get divided up? So, for example, does the creator own any rights automatically in their work, I think? So the idea is there a division of IP rights between the creator and the company?
No, really, the rights, there can be. The rights get divided whatever way the written document says they get divided. So if the creator wants to retain, what we frequently advise our agency clients to do is to reserve rights to display their work basically in their creative portfolio for their own promotional purposes. So that's a reservation of a right of display, I'll call it. If you are creating work that you want to be paid for each time it's implemented or used, then that's a license, and that's something that can be specifically provided for in writing. So the parties can divide the rights up whatever way they'd like to do, but if they don't use something in writing to do so, then the creator owns all of the rights. You can have an implied license in some situations. Again, I don't want to get in the weeds too far there, but basically and generally, the parties can divide them up as they like, as long as the writing actually reflects the way they want to divide them. I hope that helps.
Yes, that's really helpful. The right of display is an interesting one because we get that all the time. I want to come work for you. I clearly understand. TrackLight has a standard independent contractor agreement that basically you create for us, we own. But, right. You know, whatever we create, we own. So we make sure that people do have that right to display. There's another question which is on getting proper attribution for sharing others' content, like what you were talking about with the blogging and sharing. Mm-hmm. Is that mean? How does that, like, do you have to get a contract? Do you have to just get an email? What exactly is the best way to go about that?
I think any written confirmation of the permission is going to be acceptable in those circumstances because it should be accompanied by your attribution. If you're reposting someone else's content, for example, on your company blog, I would say getting written permission via an email is fine, so long as you've got that accompanied with proper accreditation on your blog of where that content came from, because you're not claiming that the work is yours and you've gotten authorization in writing. And I would say I'm comfortable with that in most cases.
Okay, and so that we almost made it through the whole time without talking about. But we have a question coming in saying, I've heard that apps cannot be patented. Is that true? Maybe it's protected by copyright, not patent.
Yeah, it's a good question. We're seeing an increasing trend with software and with mobile applications of using copyright techniques to protect the intellectual property rather than patents, because patents are getting increasingly more difficult to get for anything that the patent office might consider to be a business process. In a lot of cases, software and mobile applications fall in sort of that business process category. So we are seeing an increased use of copyright registration to protect mobile applications and also to protect sort of the visual screen, the way the screens lay out, the wireframes, the way they look and feel, those are easier to express in copyright registrations as well.
Okay, well, thank you, Sharon.
No, my pleasure.
So if people have additional questions, and please don't hesitate to contact either Sharon. Her contact information was in the last slide. And please go ahead and check out TrackLight's blog. Sharon did an amazing blog for us on this topic. And we give out free information. We have white papers. And if you want to identify any of your intellectual property and know if you have a potential trademark or a situation where you might need to protect yourself using copyright and so on, please feel free to use this 30% off discount. And we will post these slides on SlideShare, and then the link to the webinar recording and everything will be on. And I wanted to again thank Sharon for, late breaking. If you have any questions for Twitter, if you use the hashtag TrackLightWebinar, you can TrackLight, and TrackLight, you'll note, has no C. And so please share any more questions on this, and we can engage with you and make sure you get the answer. And we look forward to seeing you on our next webinar. And thank you very much, Sharon.
Thank you so much to all folks at TrackLight. It's been great working with you on this.